Well, welcome back 2024. Welcome back to your continuation of your lectures of property law. Now we're going to talk about a fragmentation of proprietary interest in real property. So it's the doctrine of tenure and the doctrine of estates. Okay, all these concepts that we're talking about, tenure, estate, incorporeal property, corporeal property, fixtures, everything, it's a derivative or it's been derived from the common law system. So basic sort of background is these are the structures that were used in the common law transplanted into different parts of democratic countries who adopted the common law, and sort of amendments were made along the way. But before, a sort of doctrine of tenure, the king or the royal family or the monarch at the time own all the land, and then they can grant an interest in the land to a person who became a tenant in exchange for services. So, for instance, all the knights that would go and fight for the king, in order for the services as a knight, they were given titles and land as well, or interest in land. So you will know about the Duke of Edinburgh or the Essex of Cornwall. So all these titles are basically title allocated to people in service of the king or queen at the time. All right, so feudal letter of tenure in England is the king was the ultimate owner of land. There was no allotted land in there. There was no land that was not held from the king or to any lord. King absolutely owned everything, or the monarch absolutely owned everything. In PNG, there's no allotted land. The ultimate owner is the state, and the person's own estate in land of the state. All right, doctrine of tenure. So the king absolute owner, tenants in chief, lords, and villein tenants. So the king will have, so this basically king on the land will say that I'll give it to a knight. So that knight was the tenant in chief. And the knight will say, okay, in my sort of army that I go and fight for the king, I have a general. So they will give it to say, okay, for this part of portion, okay, this general, you have possession of it. And then the general might bring on some farmers to work the land and harvesters and all these things. So that was the hierarchical structure of how land was owned back in the common law system. Right, doctrine of tenure, doctrine of estates. No person can own land, absolutely no land. What the order of land is an estate in land. An estate in land is a collection of rights that can be exercised over and respect of a land for a particular duration. So I'm going on to your second sort of lecture of property law now. It's the lectures of doctrine of tenure and doctrine of estates. All right, the doctrine of estates. As the doctrine of tenure perceived a division between the person who owned the land, it was necessary to determine what was the owner was entitled to and what was the nature of bundle of rights that could have exercise. The owner of real land was said to have a say-in or the entitlement to possession over land. In the medieval mind, considered the estate land was the thing that was owned and not the land itself. So the estate was that your interest in the land. When you say you own the land, in fact, what you own is an estate in land or a bundle of rights in relation to the land. All right, classification of estates. So now let's look at the estate of freehold and then the estates less than freehold. So estates of freehold are what you call fee simple, fee tail has been abolished, and live estates. Estates less than freehold are what you call leasehold. Classical example. Common feature is the duration is uncertain, unlike estates less than freehold, where their determination is certain or capable of being made or used. For instance, fee simple is basically owning a house. So when you own a house, that means that that house can be passed on from generation to generation, basically until there's no successor to inherit the house. That's then the land dies without a successor. But it's very uncertain when that interest will come to end, because the interest is passed down from generation to generation. The other fee tail we don't need to be looked at because it's been abolished. And then life estate is where the estate lasts for a life. Example, to X for life. So that's when you grant the use of a land or a property to someone or estate, and then say, okay, use it for a period of your life. And then if you come to an end, that means that the thing as well. So in other words, sort of to make it clear, it's like, for instance, I grant a piece of my land to some villagers from my village that have come to Port Moresby, and they don't have houses, so I'm sorry for them. And I said, okay, you can live with me until when I pass out, when I die, and then you can sort of move on when my kids take over my property. So it's something like that. All right, a leasehold, it's something that is less than a freehold. So leasehold is classical example is end in the beginning. So for instance, tenancy agreements, 2 years, 3 years tenancy agreements. This is what you call a leasehold. I've also given you some notes on equity sort of old on leasehold fields. I've talked about the development of the use of trust. So basically, when the common law was too rigid or too tough in its application, a sort of temporary, not temporary, but a new body of rule emerged as something to make less cruel the common law, to make it a bit more flexible and stringent. This is called the doctrine of equity and trust. So basically, in equity and trust, they developed a concept called the use of trust. So basically, for instance, if the black acre land was transferred to A and his S on trust for B and his S, you would know that basically equity will come in to try and protect them. So a classical application for this in today's world is when people want to be evicted from a place. Under law, they are not the owner of the land and they don't have any rights to live there. But under equity, the court will say, all right, give them sufficient time for them to move out of the land. So this is basically what we say when we talk about the doctrine of trusts. All right, so system of titles in land, crown land, unclaimed, land held under crown lease, so registered land held under fee simple grant. So land is registered under the torrent system and the Land Registration Act. So when you talk about registering something, basically is to give the instrument priority of all other instruments that were unregistered or registered at a later time. And basically what happens is that in order to protect your interest, you have to register your interest. For example, register your title over the land. All right, in your next sort of lectures, we will look at the torrent system and we will complete the topic on property law. Please, any questions, ask the questions. Don't be afraid. Basically, when you ask questions, you will better your understanding.